Good evening. Welcome to our Constitutional Week speaker event, and thank you for being here. I'm Wiebke Strael, and I'm the Dean of Arts, Humanities, and Social Sciences here at Newberry College. This week, we celebrate Constitution Week, which was designated by President Eisenhower in 1956 as the week of September 17 through 23rd. It is a Newberry College tradition to host a special event during that time. This year, we celebrate Constitution Week with a guest speaker. Our speaker today is Shelly Kelly, Deputy State Treasurer and General Counsel from the South Carolina Treasurer's Office. I will hand it over to Keith Ringer for the introduction of our guest speaker. Thank you.
Thank you, Dean. This is a true privilege on my behalf to be able to introduce Shelly Kelly. I have known Shelly for many years, especially when I worked at the Department of Education. She was our chief counsel there. But let me tell you a little bit about this amazing person that's going to be speaking to you today. Shelly Kelly joined the State Treasurer's Office in May 2019 as General Counsel for the agency. In 2022, she was also named a Deputy State Treasurer with responsibility for overseeing debt management and internal audit functions. She is an attorney with over 3 decades of experience in regulatory, administrative, contract, healthcare, constitutional, and education law. So you that are interested in going to law school, this is a person you need to talk to because she has a lot of experience in a lot of different areas. She also, before she worked for the Treasurer's Office, she served as the Director of Health Regulation for the South Carolina Department of Health and Environmental Control, where she oversaw the licensing and regulation of the state's healthcare facilities and services. She also served as General Counsel, where I first met her, for the State Department of Education, where she successfully litigated a landmark case against the U.S. Department of Education, which resulted in restoring more than $36 million in federal funds to the state of South Carolina. A native of Delaware, she's lived in the Palmetto State for more than 30 years. She graduated from North Carolina State University with a Bachelor of Arts in Political Science, and she earned her JD from the University of South Carolina. Let's give a warm Newberry College Wolf welcome to Shelly Kelly.
Thank you, Keith. Thank you for having me. It's an honor to be here. Great turnout. I did find out that you might have to do a paper, which is, I feel bad about that. Sorry to hear that, but it's really an honor to be asked to do this and to talk to you today about the Constitution. It is Constitution Week, and in our country, we celebrate the Constitution. We're going to talk a little bit about the history behind the Constitution. We're going to go over the text of the Constitution, talk about some court cases, and hopefully you'll find something interesting. It's maybe something you don't know, but hopefully, it's really my hope that a lot of this is familiar to you, and you will embrace the Constitution and enjoy hearing more about it. So let me start off. Give you just a little bit of historical context. In 1776, when our founders were putting, after the Declaration of Independence, we had the Articles of Confederation. And that was a very loose confederation of states. We didn't have a strong federal government at the time, and there was definitely a feeling that there was a need for more centralized power in our country. So the Continental Congress had adopted the Articles of Confederation in 1776. They were ratified in 1781, but in a few years realized there's no central leadership, there's no power to enforce laws, there's no power to tax, there's no national court system. So then there was this desire to create the Constitution. So the Constitutional Convention of 1787 was aimed at forming a more balanced governmental structure, and as you probably know, it was ratified in 1788, and the new government started in 1787. I was born in Delaware. We had the proud distinction of being the first state to ratify the Constitution. So we were always thought we were the first. We like that. We'll talk a little bit about the structure of the Constitution. There are three main parts. There's the preamble, there's the articles, and the amendments. The preamble sets the tone and purpose of the Constitution. The articles are 7, set out the structure. And there's 27 amendments that changed over time as the country evolved. The changes were needed. And a lot of this, like I said, it's going to be very familiar to you, but I hope that it'll kind of spark some interest as well. Because when Keith asked me to come speak to you, first thing I did was I went back and read the Constitution. I hadn't read it in years all the way through. As a lawyer, I study court cases all the time. And as a lawyer for the Department of Education, I always kept up with the constitutional cases that were impacted school districts, government, and you don't realize, probably as someone who's maybe considering law school or working in, or as you're going through college, you realize that how important the Constitution is every day in what we do, because every day there's litigation, people are challenging governmental actions, they're bringing cases under the Constitution. So I think this reminder is good. So the preamble, I'll read it to you. I know you can see it up there. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for a common defense, promote the general welfare, secure the blessings of liberty to ourselves, our posterity, do ordain and establish this Constitution of the United States. So the preamble outlines the three central concepts to the reader. What's the source of power? The people, we the people. The broad ends to which the Constitution is ordained, and the intent that the Constitution live on in posterity. It might be, why do we have a preamble? At the time, a lot of laws in the British system had preambles. We have preambles to laws today. South Carolina Code, many of the laws that are passed by our General Assembly have a preamble. Generally gives the reader an context of why the law is passed and the goals of legislation. Preamble's not binding, but it sets up the reader to understand what the law, or in this case the Constitution, is about. So to form a more perfect union, to build a country that could take advantage of the states when the states work together, establish justice, provide for laws and punishment in a fair and equal manner, ensure domestic tranquility, refers to peace within our country, provide for a common defense. Prior to the Constitution, the states, there was no federal system of defense, so the states would have to defend themselves. Promote the general welfare, a duty to provide the basic needs for our citizens, and secure the blessings of liberty, to have a government focused on the common good for future generations. So I'm going to go through the branches of government. Article 1 is the article that vests the power in the Congress. We have a two-part legislature, a bicameral legislature or Congress in our country. We have the Senate with 50 members now, and the House with 435 members. House is by population, as you know. And the Congress's powers, they're spelled out in the Constitution. They can tax, they can borrow, regulate commerce, establish uniform laws, coin money, create a post office, declare war. And then there's a section in Article 8 of Section 8 of Article 1 that says Congress may make any law necessary and proper to carry out the functions of the government. So early on in our country's history, that was interpreted by the Supreme Court to really establish. There was a case called McCullough versus Maryland, where there was establishment of the Second National Bank, and it was going to be located in the state of Maryland, and Maryland wanted to tax it, and didn't. So there was a lawsuit over that, and the Supreme Court found that the establishment of a bank by the federal government was necessary and proper to carry out the duties. So even though there's a whole slew of written law areas that the Congress can legislate in the Constitution, necessary and proper clause broadens that immensely. That case also established the supremacy of the federal over state laws. So if there's a conflict in laws, the federal law would govern. Legislative branch, if you want to run for House, you got to be 25 and a citizen for 7 years. If you want to be a senator, you have to be 30 first, and then 30, not 30 first, and be a citizen for 9 years. As you know, yes?
Why do they have those age limits?
It was in the Constitution. I think maybe, I don't really know why at the time. It's a good question. Why is the House, why can't you be younger for the House than the Senate? And to be president, you have to be 35. So maybe there's a thought of levels of maturity. I don't know. Mm-hmm.
I mean, since you don't know, and you a lawyer, could we sue against that? Because I feel like people be old.
Yeah. Well, I will say that it's in the Constitution, so you would not win that case. So it's actually written into the Constitution. So
if you want that knowledge, you'd have to write to a senator.
What's that?
You'd have to write to a senator.
You could write to your senator. We'll talk about how to amend the Constitution later, and that would be the way you could do that. So if there's something in the Constitution that people don't like, there is a way to amend it. It's a high hurdle to get over, but there is a way to do that. And we'll talk about it a little bit later. Impeachment. Let's talk about impeachment. There's a lot of discussion about impeachment lately. The Congress has the authority to impeach officials. The House has the sole power to impeach the official. But in order to remove the person from office, the person has to be tried in the Senate and lose the trial. I will say, over time, if you watch TV, there's Speaker McCarthy is now looking at an impeachment of Joe Biden or President Biden. There have been 60 impeachments over 60 impeachment proceedings started over time. There's only been 21 impeachments, and that's where the House has actually voted to impeach the official. 3 of them have been presidents. We had Andrew Johnson in 1868, Bill Clinton, and Donald Trump was impeached twice. Now, none of those were convicted in the Senate. So even though they're impeached, they still serve in office. Interestingly enough, there's a lot of almost every president recently has had an impeachment inquiry brought against them. Like I said, Joe Biden's got one that's pending, although it's not. I don't think it's, as of today, has been officially. Articles have officially been filed, but the day after inauguration, when he was inaugurated, there was one of the House members filed articles of impeachment against him. George W. Bush had articles filed against him. George H.W. Bush had 2 resolutions filed against him. Ronald Reagan had 2 against him. Lyndon Johnson in '68 had articles filed against him. Interestingly enough, Barack Obama did not have an impeachment inquiry during his tenure. So we do have some history of a president not being. Now, just because you have an impeachment inquiry doesn't mean you're impeached. So we'll see. There's a pretty high hurdle. There have been 8 officials who have been removed from office, and they've all been judges. So And now we step back with the impeachments. Now it's just so political now. So it it really depends on who's, I think, what political, what party's in power as to whether you're going to have a impeachment inquiry.
Why file for impeachment if you know the other party's not going to approve? Like, if the Republicans are in the House, what's the point of filing if you know the Senate is run by Democrats and they're not going to file for impeachment?
Good question. Why file if you know they're not going to follow through with it, with the Senate especially? I think a lot of it is just the politics, because when you have an impeachment in the House, you're still going to have all the evidence. You're going to have if the impeachment inquiry is voted upon and allowed to move forward, they have a right to subpoena records, witnesses, and so I think it's a lot of times just to get to the bottom. A lot of it's politics. You know, you can drag down, maybe a president has an agenda that they're trying to move forward, and then an impeachment inquiry comes, so they're spending all their time addressing the agenda, that inquiry, instead of being out there and talking to the public about, their whatever platform they're trying to move forward. Yeah, another question? Is it a waste of time? It depends. I don't know, because I think if you look at, honestly, as a government attorney, I think it wastes a lot of time. It wastes the public's, a lot doesn't get done because the impeachments are ongoing. Yeah, I definitely agree. A lot of it's just for politics. And, I don't want to get too into political commentary, but even like you're right. If you know there's not going to be a conviction, because you have to have 2/3 of the Senate. There's no way there's going to be, with the makeup of our Senate right now, it's pretty even.
I feel like they try to make the candidates look bad, but in the end, sometimes it backfires.
I agree. That's a good point. And she said, a lot of times it backfires. And we're in an election year, so impeachment inquiry, people look at that and say, okay, well, also say the Republicans are bringing this inquiry, so they're just trying to deflect from the fact that maybe President Biden, maybe he's done good. Maybe they're just trying to deflect from, make sure the public thinks he's a criminal, or that he's, involved with his son's activities or whatever. But I agree. I think most of it is political, because it's, and that's probably why we don't have that many convictions, and the convictions are judges who are probably clearly corrupt and whatnot. So the executive branch carries out and enforces the laws. The president runs for two 4-year terms if they wish to. Before the 22nd Amendment was adopted in 1951, a president could be reelected as many times as the voters would elect them. So it wasn't until 1952 where we had a change in the law, so a president was term limited. What about the Electoral College? What do y'all think about that?
Big fan.
You're a fan? Yeah, some people are fans. Some people, does anybody think we should vote?
I think since in many states, if you win the majority popular vote, you win the whole electorate.
Mm-hmm.
I think that the electoral college should go exactly off the public vote, not should be split exactly the same way that the public vote in every state.
And there's a couple states that do split their votes based on the percentage of votes in that state. I think Maine and maybe Nebraska. I have it written down.
Yeah, I think when I looked at a map of states,
Yeah.
and those ones are usually marked with
And most of them are winner take all. So, with that, there's a argument for it. It's in the Constitution. If you're a strict constructionalist, where you feel like the framers set out the way we're going to elect presidents, the framers knew what they wanted in our country, then you might say there's no reason to change it.
at the same time that they made a process for amending it because they didn't do things that to change.
Yeah, I mean, you could, I will say, there are a couple schools of thought with the electoral or electoral college, you know, you have, you know, your larger states, you might think, you know, your Californias, they have so many more votes because they're large. But if you look at how many votes they have per person or by percentage of their population, compared to like a Wyoming that has, you know, they don't have that many people live in Wyoming, so they have 3 electoral votes. So the per person breakdown is actually lower. So you have, say, 200 people voting per electoral vote, or in California, you have 800 people per electoral vote. And I probably need a little board to explain this all. But I think the biggest problem I see with electoral college now is, you know, we all, you know, it depends on where you, in South Carolina, doesn't matter, unfortunately, you know, I'm not saying Democrat or Republican, but whoever you vote for, you pretty much know this is a red state, so whatever you vote, it's probably going to go Republican. If you live in California and you're, you know, Republican, it's going to go Democrat. So, you know, you might think that maybe some of the votes are marginalized there. The other thing is, you know, it's happened in the last election. You know, South Carolina, I think South Carolina's important. I love South Carolina. So I would like the candidates to come here and talk to our citizens. But because we're pretty much a slam dunk state, they're not going to, we don't get anybody coming. Now, we'll get some of the primary candidates, which is great. So, you know, make sure you go out there and, you know, learn all you can with the primary candidates when they come. But, you know, it ends up in the last several years, there's just a handful of states that pretty much make the difference with the elections. It's, you know, your North Carolina, Georgia, Wisconsin. So, but that's the way the system was developed. So, I'm sorry?
Pennsylvania's another one of those.
Pennsylvania's the swing, yeah, that's the swing state too, yes.
Alright, so my mom, whenever she go on her little political rants, she usually be talking about all that stuff is just a way for like, I don't know, like a minority of people to control like the majority of power. Is that true?
I don't think that's necessarily true with the electoral college. And I haven't studied to be honest, I haven't really studied the like breakout, minority racial breakout and whatnot of the states. I think it really, I mean, we do know that in the last couple, well, there have been 2 elections recently where Republicans have won where they lost the popular vote. So if there was a popular vote election, at least in those 2 elections, you had a different outcome. But again, this was established with the Constitution, you know, maybe based on modern times. But, you know, over the years, the discussion comes up, and there's not really big effort to change it. So it's a higher hurdle to change. So we'll see. We'll see. Let me move on a little bit. But I like the discussion. I do like the discussion. So, judicial branch, this is my favorite, because I think you know the powers and responsibilities of I say my favorite because I've worked the most with the judicial branch, and the judicial branch, they're the ones that have interpreted these laws throughout or this Constitution over thousands of cases for many years. But the powers and responsibilities of federal court, they have, federal judges are appointed for life, so they're supposed to be impartial. They're not supposed to be swayed by political actions, although, you know, we know they're also human. So, but they don't have to worry about losing their seat. They take an oath to uphold the Constitution. Like I said, I think I said they're appointed for life. And there's only a Supreme Court written under the judicial branch, and the Congress has the authority to create a lower court system. And early on in the in 1789, the Judiciary Act was created, and it established basically the court system we have today, which is district courts or your trial courts and your Court of Appeals that are your first level, and then the Supreme Court really only hears special cases. They handle maybe a handful of cases a year. It's very hard to get to the Supreme Court. I had a case once one case where we won the $36 million case. We were actually, on one hand, I kind of wanted them to appeal it because it would have been my only chance in my entire career to argue a case before the Supreme Court. And it was a pretty significant case. I think we might have had a chance to have it heard by the Supreme Court, but the federal government decided not to appeal. But probably every lawyer's dream to try a case at the Supreme Court. On the other articles, I'll just quickly go through these. Article 4 is the state's relationships and obligations. You've heard of full faith and credit. If you have a judgment in a court in one state, it's honored in another. Talks about the relationship of the states. Article 5 sets forth the process of amending the Constitution. The Supremacy Clause I mentioned earlier, that's under the case I mentioned, that's the clause that says the federal government, if there's a conflict, the federal laws are supreme. And there was just an article about how to ratify the Constitution, which already happened, so we don't need to worry about that. So the Bill of Rights. So when you think of the Constitution, you think of the Bill of Rights, at least I do. Because that's where, your right to free speech, religion, right to bear arms, right to counsel, it derives from the Bill of Rights. So the First Amendment, probably in my political or my legal career, I probably had more involvement with First Amendment cases than any other. Because you have Congress shall make no laws respecting establishment of religion, prohibiting the free exercise thereof, freedom of speech, the press, right to peaceful assembly, petition government. We've had their school religion cases, prayer and school cases all come under that. But that's you think about that's the First Amendment. That's the most fundamental. When you think of America, and you compare the United States to somewhere, North Korea or China or other countries where you don't have freedom of speech, freedom to petition the government, freedom of religion. I think that's what you think of. To me, is the key to American life. Second Amendment is a right to a well-regulated militia being. A well-regulated militia being necessary to the security of a free state, the right of people to keep and bear arms shall not be infringed. So that's everybody talks about Second Amendment rights and their right to bear arms. And we had a little conversation about it beforehand. Does that mean right to have ammunition? Or I saw a little video one time about, it was a business place shooting, a parody, if you will. But the person walks in with a musket, and he's loading, then shooting, and the people all run out. And it's like that, that's what guns look like in 1791 or 89. We didn't have AK-47s, we didn't have handguns, so, is the right to bear arms what we think of guns now? So there's a lot of debate about that, and there's also, just because there's a right to bear arms doesn't mean that the government can't regulate. So you find a lot of regulation.
Regulated right in the, actually even says well regulated right within the.
Well, yeah, it's a good point. Well,
Yeah,
right.
that's kind of where I'm at too, because there's got to be some point to where we say, okay, this is enough, but
Yeah.
not like so strict that it's infringing on the amendment.
Yeah, I think there's the balancing of that. I mean, you have to balance, and in the courts, this is what the courts do. They'll balance the freedom of someone to have their gun of whatever type to, what kind of background checks, that's where the courts come in, and we have different opinions throughout the nation. We have some states with very strict gun laws where their gun laws have been upheld, and we have some that very liberal gun laws, open carry laws that have also, are upheld, that aren't challenged. So it works both ways. And it's an area that will continue to have litigation, keep people like me
Kids, they wanna
employed.
regulate them all you want, but during Prohibition, they found a way to still drink, so it's gonna stop them from still finding a way to get guns.
Hey, don't compare drugs to guns.
I'm just saying, I mean, I'm just saying, you have a point.
You do have
That's true. Well, it's true. You can, and that's one of the arguments for not banning guns, is because you'll never get rid of all. So, Third Amendment, we don't really worry about. It has to do with allowing no soldiers shall be required to go into your home. Fourth Amendment is on the protection against unreasonable search and seizures. The fact that the requirement that a probable cause is needed prior to searching. A warrant, it does say, yeah, you have to have a warrant or prior to a search.
or the person who's searching has to give you permission.
Or permission, or there's also, if a police officer walks into sees like a robbery in progress, that they have the authority to go in. I mean, and this is kind of where the thousands of court cases I mentioned all kind of play into this, because the Constitution doesn't really mention that. It says it's not that specific, but the cases over time have evolved. The Fifth Amendment is no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment by a grand jury. The restriction against double jeopardies in this amendment. No person shall be deprived life, liberty, or property without due process of law, nor shall private property be taken without for public use without justification. That's all in that law. A lot of the Bill of Rights involve judicial court matters. Right to a trial by jury, the Sixth Amendment. The Seventh Amendment provides for a jury trial in civil cases. The Eighth Amendment is the unreasonable excessive bail should not be required, nor cruel and unusual punishment. Death penalty cases come under that. That a lot of litigation there, and defining what's cruel and unusual punishment. And then there's a section that says the listing of specific rights in the Constitution does not mean that people do not have other rights that aren't specified. So if it's not in the Constitution, that doesn't mean that right doesn't exist. So that's actually used, again, in trying to establish other rights that people have had over time. And then the powers, 10th Amendment is used in, like my work as a state government attorney, the power is not delegated to the United States by the Constitution, nor prohibited or reserved for the states. So 10th Amendment is one of the areas we still actively litigate under. And so even though these amendments are Bill of Rights a long time ago, they're active. We actively interpret these rights all the time. So some later amendments, the 13th Amendment was the abolishment of slavery in 1865. The 14th Amendment, 1868. This is the amendment that no state may, it's what we call, the equal protection. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process of laws. That made the states, you basically took all the Bill of Rights and applied them to the state. So the state, before there was nothing that said the state couldn't do all these things. Now that here the state, you have to, the state can't infringe on your right to speak or to religion or fair trial. 15th Amendment was voting rights in 1870 that voting shall not be denied on account of race, color, or previous condition of servitude. The 18th and 21st Amendment were the prohibition of liquor and the repeal of the prohibition of liquor. 17th in 1920 was the women were given the right to vote. The 21st Amendment in 1964, another, the abolishment of poll tax for voting. We have a long history in this country of restricting people's, making it difficult for people to vote. And we still see it today with laws that are passed that restrict, if you can't get somebody a bottle of water in line to vote, isn't that kind of maybe restricting somebody's right to vote? I mean, we still see laws like that passed today. So voting rights is something that the country's been dealing with for many, many years. 26th Amendment, 18-year-olds and older could vote. And the one I found almost most interesting is not on our little chart here, but the 27th Amendment was a amendment passed in 1992 that dealt with congressional compensation. It really not that exciting of an amendment, but it was approved by Congress in 1789. It sat there, it never got ratified by the states until 1992. So 200 years later, enough states finally ratified it. It had to do with, Congress couldn't raise their pay, or the pay wouldn't go into effect till the next election is over. So Congress must have really made some people mad in the early 90s to get this, the movement there. But there was some debate about, there's some argument about, it's too long to wait for an amendment, but there's nothing that restricted it, so it passed. All right, a little bit about federalism. So we went through all the, and we don't have a whole lot of time, so I'll try to go really fast. We talked about how the Constitution is set up, but really we have this balance of power between the state and federal government. We have concurrent, reserved, and enumerated powers. Enumerated, we talked about, they're actually spelled out. Concurrent is where Congress and states share power, or they don't share, they can do the same sort of thing. You can tax, states can borrow money, federal can borrow money, federal can tax. They both set up courts, so that would be considered concurrent. Reserved are those powers that are outside of the federal government. That's the state's responsibilities. And I would give an example of education. Although there's a lot of federal laws that deal with education, there's no education. Education is not in the Constitution. It's a power of the state to establish the educational system. Now, all right, so we got, within the federal system, you got separation of powers, sort of the genius of our democracy, the fact that these three branches are separate, but they have their own responsibilities, and they kind of work together in some cases through checks and balances, but for the most part their duties are separate, and the court will a lot of times resolve those differences. Recent case, you all probably know about it, Biden versus Nebraska, where President Biden tried to give you all a break. If any of you have student loans, there was a student loan forgiveness program that would forgive up to $20,000 in some cases of student loans, and it was truly a pretty clean separation of powers issue. Did the executive have authority to forgive loans? I mean, the loan program was established by Congress. The Congress appropriates money, and I believe the amount of forgiveness was $400 billion. It was a lot of, it's a pretty, I can't remember the exact number, but the Supreme Court found that the Department of Education, which is part of the executive branch, did not have the power to do that. Congress would have had the power, would have had to take action to do that. So that's a recent example of separation of powers in action.
So education department is in the executive branch.
Yes. Yep.
But when the executive, like the president, the leader, like the executive branch, tried to change something in his branch, he couldn't do it.
Well, it was the president supported it, so he was doing, the question was related to that, the education. So through the Executive Department of Education, they tried to forgive the loans, but the loan program was set up by Congress through a statute. And so what they were trying to do wasn't aligned with the statute. They actually tried to use a different law, like which is probably not enough time to go into all that, but basically, the executive, because the education department is part of the executive branch, even though it's not the president doing it, it was his branch. Because the court talked about the Secretary of Education forgiving the loans. Of course, when Joe Biden was out there, he was saying he did it. Hey, I forgave. Of course, the president, it was his program. He wanted to forgive the loans. And I know, and there was a lot of questions about whether there would be, anyway, a lot of the states sued over this. It was an interesting case. We were following it closely because I have a daughter who has a student loan, and I had a personal interest in it. But anyway, that what the ruling was, because basically that was something that Congress would have to do. All right, so in the next few minutes, let's talk about the flexibility of the Constitution. So the Constitution's adaptability to change over time, there's our Supreme Court. And the Supreme Court, through judicial review, will review cases, and there's a debate. Should the Constitution be interpreted as the document as snapshot in time when the founding fathers drafted it? Should you look at the strict interpretation, the wording of the Constitution, or do you look at that it's more of a living document, and that as the country moves on, as time, things change? We didn't have AI back then. We didn't have a lot of things. There's so many things are different now than 250 years ago. So there's a debate, and often it comes down to who's on the court, to be honest. I mean, because you have different. When I mentioned the court systems earlier, where there's circuits throughout the country, some circuits are a little bit looser than others. They would be have a more of a living constitutionalist interpretation, where other circuits are considered a little bit more conservative and more original intent. So a lot of times it depends on the judges that are on the circuit, and the makeup of the Supreme Court. That's why it's always political. When generally conservative legislators, conservative presidents want a more strict interpretation, where more liberal the politicians or the president or the Congress, they prefer the more living, the adaptability over time. So that's why it's so important, and such a big deal for presidents to elect or to nominate Supreme Court justices. It's probably one of the most important things the president can do. It's absolutely the longest lasting impact a president can have, other than some foreign policy. I'm sure getting us in a war might be a little bit more, but as far as a lasting impact on the country, the Supreme Court makeup is definitely impactful. But just highlight just a couple cases, not too many. Marbury versus Madison, 1803, was the first case that established judicial review, basically that allowed the court to interpret laws and to declare an action of the either executive or Congress to be unconstitutional. So that kind of set up, the whole judicial review. Brown versus Board of Education, landmark case, 1954. Do racially segregated public schools violate the Equal Protection Clause? A unanimous court ruled that yes, it does. There was a case called Plessy versus Ferguson from 1896 that held that separate but equal facilities were constitutional. That case actually wasn't an education case. It had to do with railway cars. But our court, in a unanimous decision in 54, recognized that, we'll quote here, separate educational facilities are inherently unequal. So that one of the most impactful cases of our times. Miranda versus Arizona, if you like watch cop shows, hopefully you've never been arrested and had to be Mirandized. But this is the case that established that the courts, the police had to inform you of your rights. So even though you had your rights, you always had your rights, but a lot of people don't know what the rights are. So this case in 66 required the police to inform the people in custody about their rights. A lot of cases came after this about what is custody, so can't really get into all that here. Roe versus Wade, everybody's big change in, this is where strict view, liberal view, loose view. Roe versus Wade, 50 years ago, the Supreme Court found that laws that prohibit or severely restricted abortions violated the constitutional right to privacy. The court held that under the 14th Amendment, states may only restrict abortions towards the end of a pregnancy. That's law of the land for 48 years or so.
Has this case been thrown out though, prior to even making it to
Yeah.
court? Like, after, because didn't she get an abortion, prior to anything getting ruled upon? So,
No, actually, Roe ended up having the baby.
oh, that's right.
Yeah, she ended up having a baby. The case wasn't heard. As a matter of fact, if you ever do any reading on this, apparently she's a very pro-life person now. But this case, there was another case called Casey, I can't remember the other. But this shows you the difference the Supreme Court makeup will make. So in Dobbs versus Jackson Women's Health Organization last year, 2022, they found that Roe, and Casey was another case that kind of defined Roe versus Wade, must be overturned. Strict constructionist here. The Constitution makes no reference to abortion, and no right is implicitly protected in any constitutional provision, including the one which the defenders of Roe and Casey now chiefly defend, the due process clause. So this case, total, and it happens. Plessy versus Ferguson was overruled by Brown versus Board of Education. So it's not unheard of that this happens, but I think everybody knew this with the makeup of the court was changing, that it would be likely to happen, but.
Is an abortion a medical procedure?
Yes, I would think so, yeah.
So wouldn't we all have medical privacy? Like if it's a medical
Well,
procedure?
and as a question, I don't know if everybody can hear it do we have a right to medical privacy? We have rights to privacy of our medical records through congressional acts, but under the Constitution, they found that was not a right, that the abortion, that a person did not have a right to abortion. Now, if someone was prevented from having heart surgery or something, you might argue, well, that's a medical procedure, the government can't stop me from doing that, but then I would argue you have a right to life, life, liberty, pursuit of happiness. So if the government prevented you from having your heart procedure, you could directly argue it's your, this is interesting. I was surprised. I was one of the people that never thought it would get overturned, because it was the law of the land for so long, and the courts over time had kind of defined because what happens back in 1972, the viability of a fetus at 20 weeks, it just wasn't the same as it is now. So yeah, the medical field has changed a lot. So we started to see cases at the state levels where it started backing up the right to abortion to, like 16 weeks, or then we had the fetal heartbeat laws in a lot of states. And so, based on the argument that at that point, the baby can be saved. But this case went beyond that and said there's just no right to abortion. It's something, if you remember, it's not in the Constitution. Where does it go? It goes to the states. So that's how the states have the authority to allow abortions or restrict it.
Honestly, I think that's crazy. Cause like me personally, I'm 40 kids, but you can't really force somebody to have a kid. Cause I know a lot of shitty mothers out there. There are a bunch of them, and fathers too. Cause you might like,
Yeah.
you know, sit down, that's something you gotta force people to have kids.
Yeah, I mean, there are absolutely, I mean, rape, children that, or maybe the child is not viable, have some defect, medical defect, making a mother carry that child to term, all great points. I don't want to stand here and give you my opinion, that's not my role here, but I will say that you should contact your legislators. I mean, it's in the states, it's within the state's authority now. And so every state is different. South Carolina has a very strict, well, actually, South Carolina's, the law in South Carolina was just upheld, I think it's a 6 week. It was just recently upheld. I'm a woman, so, but I won't, I don't want to give it's not my role here to give you my opinion on everything, but, I feel like everyone needs to, talk to your legislators, and because it is a state, and it also could be changed by Congress. I mean, Congress could pass a law. Congress has the ability to, they could pass a law to limit or protect abortion rights. And there's been some discussion. I think even Lindsey Graham had mentioned some federal legislation to in some situations that would restrict. It'd be probably more liberal than what we have in South Carolina, but it would be more strict than what may be allowed in another state. So maybe a federal rule's not the best route, but we'll see. It's an interesting time. So I was going to go over one more case, but I was told by Keith not to go over an hour. People will start storming the doors. So. No, I'll just kidding. Well, I was just going to mention there was an interesting case this year about affirmative action. This is actually the last case I was going to mention. Affirmative action, is a process where some minorities are given preferential maybe placement or not treatment, but given maybe an advanced way of getting into a college or like years ago we've known that quotas have never been, or in recent times, even since 1978, you couldn't have a quota system to give certain minorities guaranteed slots. But over time, there have been, it's been permissible to allow minorities to have favorable admission policies because, I told you we have this long history in our country of discriminating against minorities. So affirmative action was a way to help provide minorities with, some assistance in to kind of combat that discrimination in the past. So the case is a recent case. It's pretty much made it pretty difficult to have a minority, like a provision in the admissions that would give preference to a minority, but they do. The Justice Roberts, the Chief Justice Roberts, in writing this opinion, did leave open the door that if a person writes about their life experiences and they mention their race and they talk about overcoming obstacles or whatnot, that is still can be considered. So in admissions to college. So it's interesting. I'm sure this will not be the last case we hear about college admissions and affirmative action, but it did come out this year, so I wanted to mention it. Just to wrap up. So it sounds like just in the conversations we've had, a lot of you are interested in your rights, and you want to know what you can do. You know, I think, you know, participate in the governmental process, you know, learn, you know, find out what, you know, learn about the candidates, research, just don't read what's on Twitter or what you see on, or X or whatever, or TikTok or whatever. You know, do some research before you vote, and do vote. Make sure you vote. I mean, the young people in this country have so much power. You just need to exercise it. I mean, regardless, you know, nothing against my mother's 82. Do I want her to run the country? No. We need younger people to get involved and vote, and then, you know, run for office. You know, mention the age limits. You can run for state office. I think you need 21 or don't quote me on that, but the limits are much younger for. There's a lot of college students in the state house. Get involved, and respect and obey the law. I mean, that, you know, we're a country that we establish laws. We need to obey them. If you don't like the laws, we have a process to change them. And respect. This is good. Please respect the rights and beliefs of others and the opinions of others. I mean, if you respect others' opinions, people will respect yours, hopefully. We live in a society where we all have to fight about everything. You know, somebody posts something on their social media, and everybody has to jump on it. If we just walk away and not get kind of consumed by that, I think we'll all be better for it. But remember, the Constitution establishes these rights for people to speak, to have their ideas. Now, you may not agree with them, and but, you know, hopefully if you respect theirs, maybe they'll respect yours. Get involved, get informed, get back to your community, get involved with your, you know, you want to give back, have work with kids and, you know, kids in tutor or, you know, Boys and Girls Clubs, things like that, because I think that's important. Sports, get involved with youth sports, because I know a lot of you are athletes in here. It'd be great if you could mentor some young athletes that are in the community here. So this has been fun. I appreciate this is a great group, because I like the interaction. So thank you for having me. And I hope you all have a good evening.